I'm not entirely sure because, as you may have known, the Ashcroft Alliance, the Belize Bank, they filed an application for an enforcement order. The hearing of that has now been fixed for March 14th. The government also filed two applications, one concerning the matter of post-judgment interest. It is our contention that as of the date of the C.C.J. decision in favor of the bank, interest ought to have stopped running at 17% and ought to instead have run at the statutory rate of 6%. So that's as well before the C.C.J. and is to be heard at the same time as the bank's application. The government also filed another application saying that the bank's application ought to be dismissed because there is a want of jurisdiction on the part of the C.C.J. to enforce its own decisions, that because of the peculiar nature of the treaty provisions, the constitution of this country, and other laws, judgments of the C.C.J. can only be enforced by the Supreme Court in the contracting parties. Alternatively, in that same application, the government is saying, in any event, how can the bank ask for an enforcement order and an order of mandamus against the Minister of Finance when it is quite clear that our constitutional arrangements, as well as the provisions of the Finance and Audit Act, prevent any kind of payment of a judgment debt that is not already provided for by way of the Annual Appropriations Act. Prevent payment except Parliament votes the money. We are taking advice from the lawyers representing us as to whether, in terms of the date having now been fixed for the hearing of all those applications, and in particular that last one, we still ought to proceed with the vote on the 16th of February. As soon as we have clear from our lawyers what their advice is, what their recommendation is, and that would have been discussed in Cabinet, we'll indicate to the public what the position is.